So I'm here today and talking about elections with you lovely folks. Thank you for spending your lunch hour with me. Let me see, I have one waiting room. Terry, do you have the ability to let people in?
Yes, ma'am.
Okay, if you could let people in so I could get to the
Yes.
fun of the presentation.
Yes, I will monitor the chat for you as well.
Sure. If anyone wants to go ahead and drop any questions related to elections that are burning and you want me to discuss today, I'm certainly happy to go over those questions. For those of you that this is kind of your first time, I see a lot of veterans here. I'm Christina Morgan. I'm a partner here at VF. November 1st marked my 8-year anniversary at VF. So it's been a hot minute. Never has been boring at this firm. One thing I've always loved is ever since I was an associate before I became a partner, they let us run with these seminars and teach. It has been such a fun part of our job and a happy part, right? Because most of you don't really see me or come to me unless there's something wrong or someone's being mean. With exception of document rewrites, those seem to usually be happy things. But for the most of the time, visiting your lawyer is not a happy thing. It's expensive, and you're there because you're upset. So, okay. Yes, we are going to answer some burning questions today. So let's talk about experience and elections. Obviously, the presidential election I think has really spilt over into the HOA world as far as election oversight, and we've had a lot of questions regarding fairness and rules, and I've certainly written a lot of election policies. Of course, HOA elections are not like presidential elections, but in many different ways. But we're going to talk about that and also how things have kind of changed in the pandemic and the law hasn't really caught up with us yet. There's been some good questions already in the chat, and I'm going to answer about using paper ballots and online voting and write-ins. We're definitely going to talk about those today too. I don't think I want to give up and admit that we're so close to Thanksgiving. When I originally planned this seminar, I thought, well, we're on the heels of Halloween, right? And why can't we just talk about elections? And of course, I think about all these scary movies. My son and I just went to Universal Studios for the Universal Studios Halloween Horror Nights, and they had all these mazes based on the different horror flicks, Jason, Halloween, The Exorcist, and why not that theme for our election? So you're going to see a bunch of monsters in my PowerPoint. I think it's just to keep your attention more than truly. Elections shouldn't really be that scary. They don't have to be complicated, and I think we can keep it simple, and it could be a happy, fun time. I actually love going to annual meetings and overseeing elections because I get an introduction to a new board. I kind of get their culture, what's on their agenda. And so I like elections. I've been overseeing many elections for my clients over the years. We oversee a community in Tempe that has over 3,000 homes. They're both mixed use, so they have commercial properties, and they are secret and cumulative. So cumulative meaning you have 3 votes, you can cast all 3 votes for one person. So they're very tricky. Excuse me, I'm gonna cough. Excuse me. So I think I'm gonna have to take a drink. So I've been overseeing that. It takes us probably 3 or 4 people in our office to oversee that election. And then I oversee small elections too, ones with less than 100 units. There can be controversy on how those are held. Condominiums in particular, especially when you have, I'm so sorry that I definitely don't have, I'm not 100% right now, and talking is very difficult for me right now. Okay, let me get it together so we can move on, and I'm going to share my PowerPoint. All right. Am I sharing the right screen? Okay, so I see some nods. Nightmare at Election Street. Let's move on. Okay, so annual elections. Let's talk about the law. Most of you probably already know annual election once a year. The law requires you to have an annual meeting of the members once a year. The law also requires it to be in state. Question, can I see a show of hands for those of you who know how to do your show of hands? How many of you all did your annual elections completely virtual this year? Some shake nods. Can you just raise your hand? Anyone who did all their annual elections by virtually this year?
I saw 2 hands pop up.
I see 2 right there. I saw another one. It's probably what, 40? We had about 40 people sign up today. I think it was more popular to do your annual elections in 2020, all virtually, versus this year. I think people tried to do them in person if they could. I don't know that any court in the right mind is going to be super upset in a pandemic that we held our elections virtually. And if it's virtually, is it considered in state? Most everybody who attended were usually in Arizona. Of course, we have our snowbirds and other ones residents who live here part-time. So yeah, I only saw 3 participants out of the 25 that we've got in here said that they did it virtually last year. I bet you that number would be higher in 2020. But just so you know, the statute does say it has to be held within the state of Arizona. Now, what that means for virtual meetings, we don't know, but I think it's pretty reasonable to say that if we have a compelling reason to do it virtually, that would be acceptable.
So you have a question already. What do you do if an HOA cannot get a quorum for an annual meeting and they have been unable to amend those bylaws because they cannot get enough votes for that as well?
I am dying right now. I am so sorry. I apologize. All right, let's talk about that quorum issue. I think I have that in a further slide down. Let's wait. Hold that thought for a second. I'll get to that here. Let's talk about who can vote, and then let's talk about quorum. So when and where, just so you know, the law regarding when and where, that's ARS 33-1804. That's Planned Communities B 33-1804B, and in condos is 33-1248B. There's the same statutes, Planned Community versus condo. So if you're interested in where the law is of when and where, that statute is going to tell you when and where. Understand too that the legislature also passed a law that limits liability for businesses and the spread of COVID-19. So your liability is really reduced. You have to be grossly negligent in order to have liability for spreading COVID-19 at your annual meeting. I don't know what grossly negligent means, but in our business, we've encouraged our associations, our clients, to have some type of policy regarding COVID-19, whether that's we sanitize, we socially distance if we can. And so those might be worth having a conversation about. All right. By the way, what type of notice is required is also ARS 33-1804, 33-1248. It's not less than 10 days, not more than 50, okay? Not less than 10 days from your meeting, not more than 50. So who can vote? Owners only. So what's your definition of an owner? So who's it say can vote? Usually says something to the effect in your documents. An owner, and then defines an owner as somebody who either owns a lot in fee simple or a unit. Sometimes I've seen language that says an owner will extend to an equitable owner under a purchase contract for sale. So you got to watch that about who's eligible to vote and who can vote and who is eligible to vote. Some documents automatically disqualify certain people, ones who haven't paid their dues, for instance, from voting. Some say that you have to give those people notice. If you have to give notice, what I do is I like to put out the notice of the meeting and say anyone who's delinquent or in violation is disqualified and ineligible to vote. But make sure you have authority in your documents first. You can't just say, oh, anyone who's delinquent and anybody who's in violation can't vote. You have to have that language in your documents before there's disqualification. It's also going to affect how you can count quorum too. So be careful with it. I'm gonna have to mute just a cough. Representatives. Let's talk really briefly about representatives. Representatives can attend and speak, but they can't vote. That's 33-1804A and 33-1248A. Many of you know that proxies are illegal. We can't give someone, an owner cannot give their vote to somebody else to vote on their behalf. That is 33-1812 and 33-1250. That has been the law since 2005. Oh my gosh, I'm so sorry. I just decided to have a fit. I was fine all morning until, of course, right before we did this seminar. Okay, let's talk about, before, I'm going to skip absentee ballots and come back to absentee ballots because those are kind of meat. And we had quorum questions. Proxies are legal. Do you guys like Pennywise there? It's kind of creepy. I'm going to talk about, I'm going to go back. Oh, removal petitions, nominations. Oh, look, maybe I didn't put a separate slide for quorum. Let's talk about quorum right now. All right, Terry, tell me that question again, would you?
Yes. If you do not make quorum at the annual meeting, are you required to, oh, that's a different question. There's two quorum questions. What do you do if an HOA cannot get a quorum for an annual meeting and they have been unable to amend their bylaws because they cannot get enough votes for that as well?
Have you explored other types of voting? So I would say we have to give the college try, right? On other ways to get the quorum, whether that is some type of electronic platform, providing some other method of delivery. I would say try that. Let me see. I'm looking in the chat right now. And if you don't, believe it or not, there is a way judicially, even if you can't get enough votes to amend your bylaws, to judicially get a court to reduce your quorum number. If we had that in a case, one of my clients could not make quorum for over 20 years. Just people were apathetic. They have over 1,000 homes. So we asked the court to say, hey, judge, will you reduce the quorum down to 3%? And the court was willing to do it. I think that there's going to be legislation in the air eventually about amendments and how to go about those and make them a little bit easier. If your documents are silent, though, I don't think you're required to make a second attempt. I think that was the second part of that question.
It was.
Yeah, a lot of them, it is discretionary. It will say may adjourn, you know, sometimes that's futile, but you also need to look at the optics of it. Are you going to be criticized by the membership for not making a second attempt, for not giving it the college try? You want to have elected members running the board. You do not want to have a self-perpetuating board for a couple of reasons. You know, people mistrust boards that are self-appointed, obviously. And it's good to have, obviously we choose our representatives, and we want people that represent our interests. And if we're continuing to be self-perpetuating, right, those aren't necessarily people that represent the members' interests. So I would encourage, everyone to try and get quorum the best they can. I would try and use an online platform. There's also a platform that you can use, a text to vote, where you're texted a link and then you vote from your phone and you don't even have to deal with an app. So let's talk about absentee ballots here. Let's see. I am sharing the right screen, right? Yes, I am sharing the right screen. Okay, absentee ballots, guys, this is where really there's a chunk of statutory language on absentee ballots. This is 33-18-12 and 33-12-50. These are certain things that have to be on your absentee ballots. This is where I see associations get in the most trouble. You need to set forth each action, vote for or against it. These ballots expire automatically at the end of the meeting, and you need to have a time and date for delivery. And that last one, name, address, and signature, assuming that it's not a secret ballot. Can I get a show of hands on how many people have secret ballots in either in their community, or they manage a community that has secret ballots? I see how many people I know that I'm dealing with here. Terry, count the hands.
I only see one.
Really? Only one? Secret ballots, it will say if your documents permit secret ballots, and it says that in the statute. I don't like secret ballots, I'll be honest with you. It makes it hard to track. And then we have secret ballots and you separate the envelopes from the ballot, then there's no going back. You better hope that you disqualified everyone who should have been disqualified. They're just trickier. A lot of people like it because they don't want you to know how they vote, and I certainly respect that. Especially in 55 and older communities, they really like secret ballots. If you really want secret ballots, I encourage you to make sure that that language authorizing secret ballots is in your bylaws, and that it is the expectation from your members that you're going to use secret ballots. And secret ballots, by the way, the name, signature, address is going to be on the outside of the envelope and not on the ballots itself. So when you separate the envelope and the ballot, that's when you cannot match up who voted and how. Obviously, in normal elections without secret ballots, you can match those up, and it's a lot easier to count. Secret ballots are the ones that, if they're done incorrectly, you end up having a new election. So both planned communities and condo acts say you better keep these election records for a year after your election. Note that that includes the envelopes. Even if you are having a non-secret election that's completely open, you're still required in the statute to recover the envelopes. And note that members have the right to inspect all of these election materials, including the envelopes. It seems kind of silly, especially with secret elections, because you find out who votes, and I almost think who votes is necessarily just important as not voting at all, right? You might have your opinion might be to abstain from an election, but I'm not the legislature, and having a secret ballot is kind of eviscerated by this law saying that we have to disclose and retain these election materials, including the envelopes, a year after. I don't understand it, but it is what it is. All right, let's go on here. All right, I talked about cumulative voting very briefly. And votes per lot, votes or unit. How many of you guys are in a condominium where you have a certain percentage of a vote? You don't vote just one vote for whatever property you own. Show of hands. 2 participants raise their hand. That's it? Maybe you guys are just shy today. I don't know. Be careful. We've seen a bunch of our clients that have messed with voting percentages and changed those, and they're not consistent with the declaration. Make sure your bylaws and your declaration are consistent. You'll just excuse me as I try not to snot on myself here. Be careful that those are consistent. A lot of condominiums, they will be weighted depending on how big your unit, how big the units are. Then also cumulative voting. Cumulative voting is when, say, you have 3 votes and you can put them all on one person. I technically don't like cumulative voting. They end up being like a popularity contest where Judy over here ends up getting 20 votes, and the second person, even though they got elected, gets elected with 3. But I don't know. Maybe some people like cumulative voting. If you like cumulative voting, please speak up in the chat. I'd like to know why you like it. I mean, I do see pros and cons for it, and weighting your vote, especially if you like one candidate and everyone really dislikes another candidate, maybe for good reason. I don't know. Let me see. I'm looking through the chat just to make sure. Let me answer this question really quick about write-in candidates. Someone asked, are you required to have an area on the ballot where you can write in a name? I don't know that the statute says that you have to have a write-in. And I don't think I'm so concerned about write-ins as I am about nominations from the floor. Nominations from the floor actually trouble me more. I understand the need for write-ins, especially when you don't have many volunteers. It might be the only way that you get somebody to have a seat, but I don't know of anything that requires you to have a write-in. What concerns me is that when associations allow nominations from the floor, because the absentee ballots and those being counted towards quorum, anybody who casts their vote by absentee ballot is going to be disenfranchised, meaning they're not going to be able to vote for anybody who's nominated from the floor. And so, I don't like nominations from the floor. I think they arguably violate the law. I tell associations to get that language out of their bylaws. I will say, be very careful about nominating committees. Not just because there's a nominating committee doesn't give an association the right to keep a certain individual off the ballot. If they qualify as a director, meaning they're an owner or whatever qualifications are their bylaws, and they want to run and they've submitted it timely, then I think that you probably need to put them on there. And then of course I inevitably get these questions. Well, so and so was on the board several years ago. They got kicked out because they get kicked off the board because they didn't attend enough meetings, or we thought they were stealing and they really shouldn't be on the board, or they're a convicted sex offender. Well, unless those qualifications are explicit in your bylaws that that keeps them from being a director, I unfortunately think you will have to let them run. But it's fair game saying true things of such and such is not fit to be on a director because they've been convicted of stealing $50,000 from Bank of America. I mean, assuming that's true, maybe that will get out and they won't make it on the board. Please don't take this seminar as me saying that you should go out and say bad things about your candidates. That's called defamation and it is illegal. So please don't do that. Terry, I'm going to go ahead and say the word for anyone who's getting CIA credit and is going to watch this later. The first word is Freddie, F-R-E-D-D-Y, Freddie. And we're going to move on here. Let's see. I'm going to make sure. And anyone that wants a copy of this PowerPoint, let Terry know. She can email it to you. And I think I've answered most everything in there. Those of you who don't know, I'm originally from West Virginia and who the Mothman is. Let's talk about removal elections. Show of hands and how many have been through a removal election in maybe the last, let's say, 3 years? Hands. Do I see any hands? Removal elections. Who's been through a removal election in the last 3 years? 2 have raised their hand. I've seen a lot more removal elections lately. Removal elections are interesting. It's only been in the last few years that the legislature enumerated the code on removal elections. Oh, I see. There's several people raised their hand. So in order to have a removal election, you have to have a removal petition. And the removal petition has to be signed by the right people, right? They have to be owners, not tenants that are signing, eligible voters, and you have to have the right percentage depending if you are an association of less than 1,000 or more than 1,000. If you want some light reading on removal elections, your statutes are ARS 33-1813 B and 33-1243 H. So let's look. I'm going to pull up the statute just for fun because I have a. Let's talk about. Let's see. Somewhere around here, I have it bookmarked. I just want to pull up the statute so I can just read it directly. Arizona Revised Statute. So those of you who don't know, azleg.gov, you can pull up all the statutes. And we want to go to Title 33. Someone said, please repeat the statute. Removal elections 33-1813B and 33-1243H. So anything in the 12s is condo, anything in the 18s is going to be planned community. But these, we're talking about these election statutes, they're virtually the same. All right, so I'm going down here. I'm going to pull up the statute. And I want us to talk about this directly, because this is so much fun. 33-1813. Here it is. Removal of board member, right here. I don't want to tell you the wrong thing. So we're going to just look at the statute. Oh, so much fun. Okay. So 33-1813 A4B, an A and B. In an association of 1,000 or few members, on receipt of petition that calls for removal of a member, blah, blah, blah. They have to be, so the petition, 25% of the votes in the association. So with 1,000 or fewer. So 1,000 or more is 10%. Oh my goodness, that's such a, so I guess they're trying to even it out there. I'm gonna have to mute to cough here.
Somebody asked if you would repeat that statute.
33-1813 right here. All right, let's see. So notice that if you have a removal petition presented to the board, you have to hold it within 30 days. Now, one of the unintended consequences is, what does it mean? So it talks about on receipt of a petition. The statute is kind of vague, right? It doesn't really say how the petition is supposed to be presented. I've had associations argue to me that it needed to be presented at a board of directors meeting. I don't know that that's the case. I've considered a petition as valid when it is given to a director, representative of the board. And the reason this is kind of important, why we're discussing this, is because if you don't present enough signatures for a removal petition, then game over. Then you no longer can try to recall a board member within the remainder of their term. And so it's important that, assuming any of you that are going to remove a board member, that if you're going to do it right, make sure that you've got eligible voters, not ones that would be disqualified, that meet either the 25% or the 10% in that initial petition. Either you're just not going to go any further as far as your removal is concerned. All right. So then the other devil in the details. So you call a meeting in 30 days. So say you get this removal petition. Then the other thing is, it talks about quorum for your meeting. And it says A quorum is present if the number of owners who are eligible to vote at the time the person attends the meeting equal to at least 20% of votes in the association, or the number of persons who are eligible to vote in the association at the time is equal to at least 1,000 votes, whichever is less. Most likely it'll be your 20%, right? So 20% for your quorum. I'm going to answer this question. Jeff had a really good question here. Somebody asked in the chat, can you remove a board member for no particular reason other than you don't like them? Let's see. It actually, if you look into the statute, and you can look at this when you want some light reading. Yes, you can remove a board member if they look at you sideways, or you don't like the way they dress, or you can remove them for any no reason at all. You just don't like them. Nothing stops you from removing them. There's no cause required in the statute. And I've seen a lot of removal elections for kind of dumb reasons, it's not kind of good reasons. Good reason is if they're lying, cheating, or stealing, right? All right. Again, limitation, only once during their term, otherwise they're safe for the rest of their term. And then, okay, so if you remove the whole board, you got to have another election. You remove fewer, excuse me, then you get to then you get to fill vacancies as in the documents. Many let the boards appoint them. Many documents allow that. Alrighty. Let's muddle through the rest of this. Thank you for bearing with me. It has been a rough 30 minutes for me here. Geez.
Were you able to address, and I apologize if I missed it, can you remove a board member for no particular reason other than you don't like them?
Yes. Yeah, my answer is yeah. You don't like them, you want them gone, then you can get a petition. You get the right petition, you can remove them. I've seen board members removed for absolutely no great reason. I've seen them removed for good reasons. So you get enough people who think like you, then you just don't like them, you can remove them. There's nothing in here that says you have to have a cause. And I think the legislature is like, well, let's think about the value system here. If enough people, the majority doesn't want them in, then the majority can throw them out. Okay, let's get back to the PowerPoint here. All right, I'm gonna move down. This was a limitation I was talking about. Oh, removal elections. Just like regular elections, keep your records for a year afterwards. And then we talked about quorum being your 20%. Remember that, you got to hold it within 30 days. And then I told you where the fuss is make sure the eligible voters and what's considered presented to the board. Now, the management companies, or those managers are on this call, and board of directors. Obviously, there are some people that don't trust the current regime. Sometimes it is a good thing to have third-party oversight when there is mistrust. Lawyers in particular, even though I work for the corporation, right, and I'm also bound by the Arizona rules of professional conduct. So lying and cheating and stealing is a lot harder on me because I would lose my license. So a lot of times I would rely on your general counsel, even if it's not VF, to oversee removal elections in particular, because those are extremely emotional, and people tend to question the results. And sometimes these removal elections, because how they're counted, go down to the wire of just a few votes. And so it's nice to have the oversight. I already talked about nominations and the call for candidates. I will say, you need to clean up your bylaws. If you don't want someone to be able to run for the board because they haven't paid their dues or because they're in violation of their documents, that needs to be spelled on your bylaws. Oftentimes, your declaration or your bylaws will say an owner is suspended from voting if they're delinquent, but it won't say that an owner is disqualified from running for the board if they're delinquent. Many times that's overlooked. And so somebody who hasn't paid assessments may not be able to vote, but their name could still be put on the ballot. It doesn't make any sense. There's no statute that addresses that. So you're going to have to clean it up in your documents. Question here. Can a board member be removed for never participating in regular board meetings? Well, often your bylaws will say that a board member may automatically be disqualified or is automatic resignation if they fail to attend. They fail to attend 3 consecutive meetings. You often see language for that. So if you have language, yes, they probably could be thrown off for not attending because they're considered disqualified. That's different than being technically removed. If you're going to remove someone, you're going to have to follow, unfortunately, the torturous procedure put in the Arizona statute. And I'm being a little facetious. I don't even know that it's torturous. I just think it's kind of fast and furious, right? And it's nuanced because you have to check and verify that all these owners are eligible to vote and that you have the right amounts. And there's different amounts depending on how many are in the statute. So it's tricky. All right. I did my plug for third-party oversight. Third-party oversight doesn't necessarily have to be lawyers. Your management company, they work at the majority of the board, at direction of the majority of the board. A lot of associations will have in their documents uninterested parties or uninterested owners will do the counting for the election. That could work too. Whenever I'm given the choice to let owners count ballots, I usually like to pick one from either regime, the ones who like the certain candidates and ones who don't like them. Or sometimes I just say, oh, everyone that doesn't like the board, come up and count the votes so you can see we're honest, All right, election policies. I know you can see all of this anyway. Why is this not going? No. Come on, you can do it, computer. I am not having luck today. I want to do it from the current slide. Why can't you do it? It won't even let me move it. Well, I'm frozen right now, but that doesn't stop from talking. All right. Election policies. So they're not mandatory to have an election policies, but some things are good idea. Election policies, there you go. Removal petitions. There we go. Here are some things that you might want to think about putting in an election policy. Oftentimes I get, well, they didn't get their bio in by 2 days. Do I still have to include it? The mailing hasn't gone out yet. We haven't printed it. Well, why wouldn't you? Did you have a rule that says this is a hard and fast date and you have the right to disqualify them or not accept their bio? I don't like messing around with those types of things. I want to be fair. And if you haven't been explicit on when you need to turn in candidate bios, I don't like it when associations say I'm not going to accept them. If you haven't been clear, it's kind of like your children, right? And boundaries and them trying to get around it. If you aren't clear, then I don't think it's fair to reject candidate bios. Also, what form of candidate bios? Some associations have their own form. Some will say, 1 page, single space, don't put anything offensive in there. You would be surprised the strange things that you see in candidate bios. Ballot appearance. How's the ballot going to look like? I think structure is great, and relying on ones that have been reviewed, particularly by council, then just have all those things that by statute were required are great to use versus everyone kind of making this up as they go. How are the ballots going to be delivered? The statute. So pandemic wise, let's talk about this. The statute, I'm gonna pull this up. So let's see, let's go back to Title 33. We talk about, it's interesting about the, what was I gonna say? The statute here and absentee ballots. I'm gonna go back here. So look at this. This sentence right here. No, shall comply with all the following if absentee ballots or ballots provided, right? So it has to have these things. Actually, the line before it is the one that gives me pause in the pandemic. The association shall provide to be votes to be cast in person and by absentee ballot, and in addition may provide for some other form of delivery, including email and fax. So I think under the statute, and I had somebody argue with me not very long ago, maybe a month ago, that we could just do, they could just do email. They could email ballots to everyone, and they didn't have to send paper ballots to everyone. And I kind of got upset because they said, hey, look at the statute. The association shall provide for the votes to be cast in person. In person. I think we're coming out of the pandemic to a certain extent with a vaccine available and people being more willing to meet in person. And so I am very hesitant to tell associations that they can't provide some type of delivery physically. But anyway, do what you may with that language. I do think that election policies, though, should spell out the methods of delivery that are acceptable. Some associations don't want to mess with email or fax. They're very hesitant to accept things by email or fax. Some associations need to. There's plenty of people who have not been able to return from Canada, for instance, among the pandemic, and haven't been able to vote. The mail was too slow. 30-day turnaround was not good enough. And so I think you're going to have to be reasonable. There are some associations where they had hardline rules about accepting electronic votes where I said, hey, you need to be flexible. You need to allow the folks from Canada to vote by email because there's no other way we're going to be able to get it in time. And I don't want to just disenfranchise my poor Canadians there. They should be able to vote in their HOA election. Let me go back to the slide. And then, so ballot delivery, how are you going to accept the ballots? Are you doing it online? Are you doing it by email? Are you doing it fax? Where are you doing it in person? And then what type of oversight will members be allowed to vote, or sorry, to oversee and count the votes? Who's going to be counting? A third party, a lawyer, and how much are you willing to spend? Some associations, which I flat fee, by the way, my oversight of certain elections to make it affordable. To associations that just don't want their management company involved in the politics of board elections. There was a question. Board adopted a code of conduct to be signed by each director. After the annual meeting, one director refused to sign it. What options does the board have with this one director? The jaded answer and correct answer is not much. There's nothing that requires a director to memorialize their already legal obligations in a code of conduct. They inherently, as becoming a director, they have fiduciary duties under the common law. They have the duty of care, the duty of loyalty, the duty of care being that they have to do their due diligence. They have to make decisions what they think is the best interest of the corporation. And the duty of loyalty, conflicts of interest, they can't go out and hire their cousin to be the landscaper, that kind of thing, without disclosing it. So, but the answer is not much. There isn't really law that requires, please forgive me for blowing my nose here. Maybe I should just go off the camera altogether. There isn't much that you can do. So I like, in theory, conduct. I think you already know who's going to be cooperative and play nicely with each other already. I don't think that it sets a very good tone, right? If a director immediately says that I'm not willing to follow a code of conduct. Code of conducts, I like them. We often use them. Most management companies use them. Maybe that's something the legislature should look into. Maybe it should be codified more. There are the standards of care, the duty of care, duty of loyalty is already enumerated in the Arizona Nonprofit Corporation Act. So, I mean, it is statutory. It's also case law. Maybe the legislature has just always thought that it wasn't needed because it's already there. It's already part of the law. But maybe there does need to be something separate. whether or not you advocate for a separate regulation for the HOA industry, I think that that's one of the questions. I think everyone's kind of scratching their head. You have volunteer members, right? And if they're not going to willingly follow the law, then we have a problem. I would say in that case, I would really encourage that board and that management company to go get in front of someone, legal counsel, and have a board boot camp on fiduciary duty and all the obligations of new board members. That I think that it's going to be really important, the education component for a board member like that. Okay, another question. On suspension of voting rights, the RCCNR state that an owner cannot vote if they fail to pay an assessment. Would that also include any fines incurred, or does it need to be spelled out explicitly? So, in a nutshell, can we suspend voting for fines? It needs to be spelled out. A lot of association documents will say you're suspended for non-payment of anything under the declaration, and then I would say fines were included. But if there's language that says they're only suspended if delinquent in assessments, then I think that you're gonna have to stay with delinquent in assessments. A lot of times it will say if you're delinquent in assessments or you are in violation of any of the documents for a period of not more than 60 days. So you could suspend them 60 days following a violation, for instance. It just depends on what your documents say, and I would clean that up if you could. And that's another thing. Election policies, you can clarify language that you already have. If there was broad language that said an owner is disqualified from or suspended from voting for being delinquent in any amounts under the declaration, you could say in your policy, any amounts includes and is not limited to assessments, to fines, to management charges, anything like that. So manage your expectations with your policies. What was I going to say now? I think I'm pretty much I'm going through right now. We went through removal. We talked about cumulative voting, retain your records for a year, secret ballots. I'm not a huge fan, but they're certainly serve their purpose. Absentee ballots. Just so you guys know, those statutes that I was citing, let me pull these up here. I'm going to put this on my other screen. So I have this little sheet outline that I've been using that I'm showing you here. And I've listed, if you look 33-1804, 33-1248, I have this absentee ballots. This is that 33-1812, 33-1250. This is the meat of what needs to be in absentee ballots. There's like 7 different provisions. We went over very briefly today. I know we only have an hour about what those 7 things were. This is really what I'm looking at when an association's manager or a director comes to me and says, Christina, take a look at my ballot. I'm matching it up against this statute and this little cheat sheet that I have for absentee ballots. I think I have, and so I will say, so let me tell you something. Okay, so not everybody will get an election right. We all know that things happen. I have seen elections go terribly wrong. So what happens if it goes terribly wrong and we don't think it's fair? We have another election. That's your remedy. Very rarely do elections themselves end up in court. And because a lot of times you can go back and you can say, well, we don't know how we got to this conclusion. And so since we can't trace it back with our records, then we're going to have another election. Somebody asked in the chat, can I share the syllabus? Absolutely. Happy to do that. The syllabus has these specific citations to the statute, and I think I think that's very helpful, right? So Terry, if you will share the syllabus with everyone, please. This is my dirty outline for this presentation. I've been doing this for a few years. As I said, elections are great to me. I love elections. I think it's kind of like math. It is math. There's so many votes and there's so many that aren't. I like to you have to be careful too. I will say, be careful with your disqualifications. Be careful with the things that are unclear with your documents about how you're supposed to disqualify or suspend, whether you have to you can automatically suspend, whether you have to give notice. Make sure your notice is given in the right time, and make sure there's some type of oversight. Are there any other questions while I have you? About 10 minutes. And again, I apologize. I have been so under the weather. I do not know what's got into me. If somebody could spread some healthy vibes to me, I'd appreciate it. So I stopped getting these nasty colds right before these seminars. It would be great. Oh, let's do the last. Let's do the last word here. Let's use the word Michael, 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 for the CI credit. And if you think of anything else that you are burning to know, dying to know about elections, please email us. I'm happy to answer those questions. Good luck. I think I'm hoping that we all get along better in 2022, and I don't see as many removal petitions on my desk as I did between 2021 and 2022. And I see a lot happier elections and people cooperating. I think we will. What's the email? Terry, if you could drop your email in the chat, please, so we could everyone could get the PowerPoint and then the syllabus with these different citations for the statute. Well, thanks so much. It's been about an hour.